Patriots, the Supreme Court just heard oral arguments in a case that could determine when police can enter your home without a warrant and potentially confiscate your firearms. And Justice Amy Coney Barrett just called the lower court's ruling sloppy. We're talking about Case v. Montana, a Fourth Amendment case that builds on a previous 9-0 unanimous Supreme Court decision protecting your home from warrantless searches. This case involves police shooting a man in his own home after entering without a warrant based on an ex-girlfriend's bad feeling. And the Montana Supreme Court upheld this warrantless entry using the WRONG legal standard. Before we break down the oral arguments and what the justices said, smash that subscribe button. Happy New Year 2026. Let's make this year huge for constitutional rights. Let's hit 900,000 subscribers. Let's dive into this critical Fourth Amendment case. The case of Facet, me tell you what happened to Trevor Case because these facts are disturbing. Mr. Case had a phone conversation with his ex-girlfriend. She didn't like something about the conversation, so she called the police saying she had a bad feeling. When police and the ex-girlfriend arrived at Case's house, she told officers she couldn't remember exactly what he said, but she had a bad feeling maybe he would shoot himself. Maybe he would shoot police maybe. She heard he had a firearm. That's it. No specific threat. No observable emergency. Just a vague bad feeling from an ex-girlfriend. The officers knew Mr. Case had a history of mental health issues. For officers arrived at his home and spent 40 minutes looking through windows, knocking on doors, shining lights, calling for Mr. Case. He didn't respond. They saw an empty holster and a notepad through a window, but no emergency. No one screaming. No one injured. After 40 minutes, the officers decided to enter through the unlocked front door without a warrant. 2 officers went upstairs. One entered a bedroom. He saw a closet curtain move, revealing Mr. Case's face. The officer claimed he saw a black object, and the officer shot Mr. Case. The bullet hit Case in the arm, passed through into his stomach. Case was wounded in his own home by police who entered without a warrant. Police then searched the home and found a handgun in a laundry basket near the closet. This is exactly the kind of situation the Fourth Amendment is supposed to prevent. The Fourth Amendment, VIO Litioine, Mr. Yo. Case argued that the officer's warrantless entry violated the Fourth Amendment. Therefore, the gun and all evidence found should be suppressed. The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Your home is your castle. Police cannot just enter without a warrant unless there's a genuine emergency. But the Montana courts rejected Case's arguments. The trial court denied suppression. The Montana Supreme Court, in a 4-3 split decision, agreed with the state. Here's the problem. The Montana Supreme Court didn't use the correct legal standard. The U.S. Supreme Court established the standard in Brigham City v. Stewart. Police can enter without a warrant when they have an objectively reasonable basis to believe that an occupant is seriously injured or threatened with such injury. But Montana applied a lower standard, basically just reasonable suspicion that something might be wrong. This is a huge difference. Objectively reasonable basis of serious injury is a high bar. Reasonable suspicion something might happen is a much lower bar. The Brigham City PRCD, and let me explain the Brigham City case because it's critical to understanding what Montana did wrong. In Brigham City v. Stewart, police responded to a noise complaint about a loud party through a window. They saw minors drinking alcohol, shouting, and fighting. An adult punching a minor. Police entered the home, stopped the fight, and arrested the adults. The trial court said this was an unconstitutional, warrantless search, but the Supreme Court reversed unanimously. The Supreme Court said, when police have an objectively reasonable basis to believe someone is seriously injured or threatened with serious injury, they can enter without a warrant under the emergency aid exception. This is a narrow exception. There must be observable facts creating an objectively reasonable belief that someone faces serious injury or odgets t unowed bout. A bad feeling. Not maybe something might happen. An objectively reasonable belief of immediate, serious injury. Montana ignored this standard and made it much easier for police to enter homes without warrants. Justice Barrett's sloppy COME. Now, let's talk about what happened at oral arguments. The Supreme Court justices focused heavily on the fact that Montana applied the wrong legal standard. And Justice Amy Coney Barrett dropped a bomb. She called the Montana Supreme Court's ruling sloppy. This is huge. Supreme Court justices rarely use such direct language criticizing lower courts. Justice Barrett wasn't alone. Multiple justices expressed concern that Montana didn't properly apply Brigham City. The consensus seemed to be, Montana messed up. They used a standard that's too permissive for police and not protective enough of Fourth Amendment rights. This is great news for constitutional rights. Even the conservative justices recognized that Montana went too far. The Trump Doge POSITO, here's where things get complicated. What legal standard should apply? Mr. Case's attorneys argued for a probable cause standard, the highest level of proof. They want the strictest protection for the home. But the Trump DOJ argued against this. They want a sliding scale of reasonable suspicion, depending on the circumstances. Montana wants a firm, reasonable suspicion standard. During oral arguments, it became clear that none of the justices, not even the most conservative, supported the probable cause standard. Many justices expressed concern that probable cause would be too difficult for police to meet in genuine emergencies. Justice Alito and others worried about situations where someone's life is at stake, but police don't have probable cause yet. This is disappointing from a civil liberties perspective. But the reality is, the Supreme Court will likely stick with something close to the Brigham City objectively reasonable basis standard. Likely OITCOM, based on oral arguments, I predict the Supreme Court will reverse the Montana Supreme Court. But there are two possible ways. Option 1, vacate and remand. The Supreme Court simply says, Montana, you applied the wrong standard. Go back and apply Brigham City correctly. Justices Barrett and Roberts mention this option. It's the easier path for the court. This would send the case back to Montana Supreme Court with instructions to do the analysis correctly. Option 2, decide it themselves. The Supreme Court applies the Brigham City standard themselves to Mr. Case's situation. They would review the facts and determine, did police have an objectively reasonable basis to believe Case faced serious injury? Mr. Case's attorneys advocated for this option. They argued that if the Supreme Court is going to correct Montana, they should provide clear guidance by deciding the case themselves. This would give lower courts a concrete example of how to apply the standard. My prediction? I think the Supreme Court will choose option 2, decide the case themselves and provide guidance. Why? Because Montana's error shows that lower courts are confused about the standard. The Supreme Court needs to provide clarity. And based on the facts, I think the Supreme Court will find police did not have an objectively reasonable basis to enter. Why this matters for gun OWN arrest? Let me explain why gun owners should care deeply about this case. First, warrantless home entry. If police can enter your home on a bad feeling, they can do anything once inside, including confiscating your firearms. SECOND, red flag laws. Many states have red flag laws allowing gun confiscation based on vague concerns. If police can enter on reasonable suspicion, red flag enforcement becomes much easier. Third, ex-partner accusations. In this case, an ex-girlfriend's vague concerns led to a warrantless home entry and shooting. Imagine bitter ex-spouses using this to trigger police raids. Fourth, mental health stigma. Police knew Case had mental health history. They used this to justify entry. This creates incentives for gun owners to avoid mental health treatment. Fifth, property rights. Your home is supposed to be your sanctuary. The Fourth Amendment protects against government intrusion. This case tests whether that protection is real or just words. SIXTH. Precedent. Whatever standard the Supreme Court establishes will apply nationwide to all warrantless entry cases. This case is about whether your home is truly your castle or just another place where government can exercise power without warrants. What gun owners should DOE if you're a gun owner concerned about warrantless home entries and gun confiscation? Here's what you need to do. First, understand your Fourth Amendment rights. Know when police can and cannot enter your home without a warrant. Second, be careful about red flag laws in your state. Anyone can make accusations that trigger investigations. Third, document everything. If police enter your home, document what they said, what they observed, and what they did. Fourth, get legal help immediately if police enter your home without a warrant. Don't talk without an attorney. Fifth, support organizations fighting for Fourth Amendment rights. Civil liberties protect gun rights. Sixth, watch for the Supreme Court's decision. It will likely come in spring or early summer 2026. All right, Patriots, that's the breakdown of Case v. Montana and the oral arguments at the Supreme Court. Let me summarize. Police entered Trevor Case's home without a warrant based on ex-girlfriend's bad feeling. Officer shot Case in his own bedroom. Montana's Supreme Court upheld warrantless entry using wrong legal standard. U.S. Supreme Court heard arguments. Justice Barrett called Montana ruling sloppy. Court will likely reverse Montana and clarify emergency aid exception. Could provide major guidance on warrantless home entries. Huge implications for gun owners and Fourth Amendment rights. Happy New Year 2026. Let's make this year huge for constitutional victories. If you found this valuable, smash that like button. Share with gun owners concerned about warrantless searches. Subscribe for the decision when it drops. Comment. Do you think police had justification to enter Case's home? Or was this a Fourth Amendment violation? Until next time, stay armed, stay free, and know your rights. The Fourth Amendment protects the Second Amendment. God bless America.